Thank you, Chair Chavez. Our only item today has two sub-actions. Item 3.1 is receiving and filing a public memorandum from the City Attorney's Office in response to a staff direction. Madam Attorney, would you like to speak more on this item?
Thank you, Council President. I can just sort of briefly go through my memo. The request for the memo was, what is the procedural process for amending the settlement agreement? There are three situations where we've done this in the past, all of which have been regarding deadlines, moving deadlines that are in the settlement agreement. So sort of briefly, there's kind of an internal process and then there's an external process. The internal process is not formalized, but it's generally resulting as a result of communications amongst the city administration staff that are charged with implementing the terms of the settlement agreement about whether there are existing terms that present an operational barrier to successful implementation and should be changed as a result. So the examples of the changing of deadlines is an example of that, where one was changing deadlines for actually hiring the independent evaluator. Another was changing deadlines for when the independent evaluator was in place. They had a deadline for completing an evaluation plan that was too short for them to be able to comply with. And then the third was once that evaluation plan was finished, then we sought court approval of changing the deadline so that instead of the deadlines running from the effective date of the settlement agreement itself, which was the date of court approval, instead if those deadlines ran from the date of retention and onboarding of the independent evaluator, so that the independent evaluator actually had a full year's worth of data to be able to review in their first year. So that's again, the changes really are surfacing from the city administration staff that are part of implementation. And then there's always a review by the city attorney's office on any desired modifications to determine whether they are legally and factually supported and can be presented to the court for approval. Because this, again, it's a court enforceable agreement. The court has retained jurisdiction in terms of overseeing the agreement, and so any changes that we want to make have to actually pass muster for court approval. And for our job, we are bound by the Minnesota Rules of Professional Conduct only to make requests of the court that have a good faith basis in law and fact. So any time an amendment would be proposed, it would have to go through our office, and we would have to do the in-depth legal and factual analysis to determine whether there is in fact a legal and factual basis to present them to the court for approval. So that's kind of the internal process. Externally, would include really a couple of parts. One would be in negotiation with MDHR, and the second, again, would be court approval. So in terms of negotiation with MDHR, it would be a negotiation between the two parties. If agreement is reached to jointly seek court permission to amend the settlement agreement, that agreement would have to take the form of a stipulation, which is basically a formalized pleading that is submitted to the court that indicates the agreement of the party and the why. What's the legal basis? What's the factual basis of making the request? That stipulation, again, it's a formal pleading that's submitted to the court. It's signed by the city attorney's office as the representative of the city, and by the Attorney General's office as the representative of the Minnesota Department of Human Rights. The Minnesota Department of Human Rights does not have the ability to represent itself in court. That's always done by the Attorney General's office. The stipulation, again, would explain the agreed upon changes, the basis for the changes, submitted to the court along with a proposed order for court review and approval. And then finally, any stipulated changes can't go into effect unless they're approved by the court by a court order. If the court signs an order approving the changes, then the settlement agreement is so amended to the extent of that court order.
Thank you for that explanation. Do colleagues have questions or comments? Councilmember Wansley.
Thank you, President Payne. I actually want to start with the original memo that was shared with Council regarding the legality of the staff direction, but also it's the one that was waived via our vote last Cal. So first, I want to dive a little bit into the first section of that memo, where I'm seeing that the CAO outlines that the process to negotiate the MDHR settlement would essentially be the same process as any other contract that the city pursues. And that process essentially says that the mayor has the sole authority to renegotiate all contracts, and council's role is to either approve or deny those contracts, which that's clear enough. And I want to get a little bit more clarity around, though, this piece where there's a statement in the memo that says neither the council nor the mayor may give the CAO a directive that infringes on the professional responsibilities of the CAO, and directing the city attorney's office to act without regard to its professional responsibilities is not permissible under section 15200 of the city's ethics code. So my question for our city attorney is this essentially a general statement about a hypothetical situation, or is it the opinion of the CAO that it's the mayor who has the sole authority to negotiate contracts, and that essentially would be the lead for any renegotiations around the MDHR settlement agreement?
Madam City Attorney?
Yeah, so council members, Councilmember Wansley, council members, I mean, I think that in this particular memo, I talk specifically about the directive to modify the the settlement agreement to include the terms of the consent decree. The really, really important point about that, and I mentioned it in the public memo that I just read from, the settlement agreement is a court enforceable, court-approved document that the court is still retaining jurisdiction over. So this is not like a normal contract where, you know, the parties just come together and whatever they agree to it's fine as long as it's not like overtly illegal. This is a situation where in order to get any changes to the settlement agreement, it has to go to the court for approval. And that puts the city attorney's office in the position that we frankly always have as officers of the court. So when we actually make representations to the court, submit documents to the court, we are bound by our ethical responsibilities, by our licenses, to only make meritorious legal claims that have a good faith basis in law and fact. So in this situation, I know in the memo we talk about, you know, the mayor's role, the council's role, but what it really boils down to in this situation is, regardless of what the mayor wants, regardless of what the city council wants, the city attorney's office has to do our independent legal analysis, factual analysis about what amendments have a legal and factual basis in order to bring them to the court. My office has done that legal and factual analysis, and we have concluded that, in fact, there is not a legal or factual basis for us to ask this court that has jurisdiction over just the settlement agreement. It's a dispute between two parties, right? MDHR and the city. And we have completely resolved that dispute with the terms of the settlement agreement. In order to go to the court and ask the court to increase the settlement agreement by about a third, I would have to have legal and factual basis to do that, and I don't have that. I can't make the representations to the court that I would have to make, that in fact these new additional terms are somehow necessary to resolve the dispute before the court, which is the dispute between MDHR and the city that has been completely resolved. These are terms that we negotiated with a completely different party to resolve a completely different lawsuit in a completely different forum. We don't have the legal or factual basis to go to court and ask the court to expand its jurisdiction. Just because we want it does not mean that we can ask the court to do that. The court just doesn't act just because we want it to. We have to actually present to the court that these terms are actually necessary to resolve a dispute between the two parties before it MDHR and the city, and it's just not the case. We've already resolved that dispute with the terms of the settlement agreement. So in this particular situation, I know, again, in our memo, we have a long explanation of the role of council and the role of mayor and who gets to do what with the police department and who gets to do what with negotiation of contracts. But this is such a special situation where we are talking about a court and our special role as attorney, as independent, frankly, officers of the court that can only make good faith legal arguments and factual arguments to the court. So that's what this boils down to.
Thank you for that, City Attorneys. I do think the ultimate piece was, or the basis of my question was not necessarily answered, and I think it gets reiterated in the other components that's addressed in that same memo, where it also talks about that, or states the city attorney's office reviews any desired modifications to determine whether they are legally and factually supported and can be presented to the court for approval. So again, the baseline is, and this is where the directive came from, because I want to highlight for 6 months, it was this body's understanding from consultation with the city attorney's office that pursuing modification that's included not only in the MDHR settlement agreement, but also the consent decree terms, allows a stipulation for us to jointly come together to modify. Essentially, who gets to pull the trigger on that? And I think it's honing in on your second memo, which I still don't understand how we don't have an internal process for that, when we did have an internal process for that in 2023 to get into the MDHR settlement agreement. And at that point, it seemed that the mayor authorized the city attorney to go in the process. I'm asking if that still stands. Who submits or authorizes the city attorney to essentially make a review of modifications to then approach MDHR?
Council members, I and the city attorney's office have independent authority to represent the city. We are the lawyers for the city by charter. I don't need to get a directive from anybody to do legal review. That is my job. That is what I do all of the time. And that is what I did here. I was hopeful that this was a path forward, but then I dug in and did the legal research and talked to the experts in my office and found that there is not a legal path forward.
And I think that's the piece. I get that you said that the scope of authority that you're finding, and I think we asked this too, if you consulted MDHR about your findings in terms of, because there's lots of things that's in that consent decree. There's behavior responses that overlaps with components that's included in our MDHR settlement agreement. That's not related to constitutional policing or constitution at all. So there's so many provisions in there that does seem like it would apply or could transfer over. We're also hearing from other legal experts, even the former city attorney, that says there is the ability, and they were in charge of helping us initiate the first process. So I'm still not understanding what is that legal basis. I get you're saying it's up to the court, but this provisions allows, from my understanding, the city attorney and MDHR to do that joint review of what terms could be brought over to then present to the court together, and then let the court or the judge, presiding judge, make the decision. It seems in this case, the CAO, as you're highlighting, is acting independently and saying, we're not even going to try to do the review.
Madam City Attorney?
Council members, so I did do the review. I did do the review, and I have thought deeply about this. But at the end of the day, whether MDHR wants to do it, whether we want to do it, I have to be able to make representations to the court in good faith that these terms are actually necessary to resolve the dispute between MDHR and the city. And they're just not. We've already fully resolved the dispute between MDHR and the city. There is not a path forward. There is not an argument that I can make that, in fact, it is necessary for the court to take over jurisdiction of these other terms that were not part of resolving the actual case or controversy between the city and MDHR. So I, as an officer of the court, have to be able to, in good faith, make representations to the court, and I can't in this situation.
And just going back to this other piece of, why did you include, or was it the pursuit of both parties, the city and the Minnesota Department of Human Rights, to include in both the settlement agreement and the consent decree the basis for modifications? You're saying in your memo, the president right now is around deadlines and timelines. But you've also shared we're in unprecedented times. And from my understanding and reading this provision, it does not say it's limited to deadlines. So essentially, are you saying that this provision of being able to do modifications on both agreements that were negotiated by both parties is essentially moot? It was just around the ability to do deadlines, not to pursue other substantive changes, especially in light this happened before the DOJ settlement agreement, where there was the assumption that changes would have had to be made to the settlement agreement. So again, it's unclear of if you all knew that it was not legally viable now, why would you include this provision in the first place?
Madam City Attorney.
So, council members, the amendment provision in the settlement agreement is a pretty typical thing to include in contracts. And no, it is not supposed to include major scale additions. Again, to fold in the consent decree terms, it would increase the settlement agreement by about a third. And again, terms that were not negotiated with MDHR were not required to resolve the dispute with MDHR. It was not contemplated, at least by me, and I was in the negotiations as soon as I got here in late September of 2022 now. I sat through all of those negotiations. So it was absolutely not my contemplation that that amendment term could be used to increase by a third something that had already been settled. We did, in the settlement agreement, account for if there were direct conflicts between the consent decree terms and the settlement agreement terms, that we would go back and renegotiate those things. That's not where we're at right now. There are no conflicts between the consent decree and the settlement agreement at this point, because the consent decree is not enforced by the federal court. That was the reason why we included that is because we assumed that there would be a federal court involved, and federal law always trumps state law. And so we agreed with MDHR that we were going to modify the settlement agreement to account for any conflicts between the two. But we never discussed modifying the settlement agreement to include provisions from the consent decree under any terms, whether it would be because the federal agreement never happened or because the federal agreement did happen. We never contemplated that. It is not addressed in the settlement agreement. And again, we resolved all of MDHR's claims. We could have left things open for additional negotiation. We did not. We completely settled all of MDHR's claims. We are not in a position, again, to ask the court to expand its jurisdiction to include terms that are not necessary to resolve the dispute between MDHR and the city. And I cannot represent to the court that it is necessary, because it's just not.
So just walking away from this whole piece, where, again, the goal, I think, and this is a shared goal, is we want to see a police department that upholds the constitutional rights of its residents and to have a legally binding agreement that enforces that. That right now is absent with the dismissal of the DOJ consent decree. In light of that, it's unclear that right now, and this is where we got to the directive for the CAO, we're being told that the CAO has made the independent decision of itself to not even pursue a pathway for exploration, because you're naming to not bring claims that are outside the scope of the court's authority. What I'm not hearing is there hasn't even been consideration of what terms could be included, and those have not even been brought forward. So you're saying the CAO is independently making a decision to not pursue this particular provision, regardless of the direction of the mayor or council. Council member, again, we have done the legal analysis, and there is not a basis for me to go to the court
and make representations to the court that additional terms need to be added in order to resolve the dispute with MDHR because it's already resolved. I can't make representations that are not in good faith. That is just not something that I can do under my rules of professional responsibility. And frankly, back to the question that you asked, it is a violation of the ethics code for you to direct me to do something that I have told you in the exercise of my professional judgment I cannot, consistent with my professional responsibilities, do. So I have done the analysis. I have not found a legal pathway. We do have a shared commitment to making the reforms. The mayor issued an executive order. That executive order is binding.
Is it legally binding?
It is binding until
legally binding.
It is binding until the next mayor revokes it, which I think politically would be a very, very difficult thing for any mayor to do. I wish that I could get you a court enforceable document. I worked so hard, nights, weekends, trying to get the DOJ consent decree negotiated and submitted in time so that we could have gotten court approval. I did everything that I could. It didn't work. I wish that it did. Believe me, of anybody who has skin in this game, it's me. And I tried my hardest, and it did not work. What I can't get you, what I can't get the mayor, is a court to enforce these terms. There is not a pathway for me to do that, consistent with my professional responsibilities. And no, I'm not going to go to the court and say, well, I don't really have a legal basis to do this, but why don't you tell me whether we can do it or not? I have to have a legal basis. I have to be able to make those representations to the court, and I can't.
And could you do a modified memo that reflects that? Because I don't, again, in your memo, you talked a lot about the government structure components. You reiterated that. It is still not clear in what terms you did the review, but you're saying all 400 provisions, from behavioral responses to chain of command, those provisions, things that are already under the guise of the authority of the mayor, you're saying none of those could be folded over into the settlement agreement, and that could be outside the scope, and that just because you settled, that you cannot reopen renegotiations. And that just does not seem clear in the fact that we're hearing from other legal experts that there could be a pathway. And for 6 months, we heard also from the CAO, your office, that there was a pathway. This just does not seem, it doesn't seem solid. And this is not a reflection on you, Kristen Anderson.
I mean, how is it not, truly?
No, Kristen. Or CAO Anderson.
Let's stick with titles, please. Yeah,
CAO Anderson, this is not a reflection on personal. You highlighted in your memo that the CAO office has the public good in mind. Public good is a legally binding agreement that gets our police department into compliance with constitutional law. That is a public good. The public good that I know you advise us on around legal risk is making sure residents don't have to continue paying for settlements because of victims who have been subjected to their constitutional rights being violated. And residents having to pay out millions and millions of dollars to that or PTSD settlements because officers are also putting themselves in compromising positions. So that is the basis. This is not reflective on any personal dynamics at all. We were advised by the office for 6 months that this is viable. And we're asking, has literally every avenue be exhausted? Because to go from 6 months to literally in one day, a completely 180. And we're getting very clear. You're saying the council cannot direct you. But my questions was, has the mayor even made an effort to also make the directive? Because I'm going from the original memo where you said the mayor is within the authority to settle contracts. And just getting clear on that chain of command that was not fully fleshed out in the second memo.
So, council member, I have advised the mayor, just like I have advised you, that there's not a legal pathway forward. I don't know what else to say. I know that there are lots of legal experts out there that are out there second guessing. I have been practicing law for 28 years. I've been a public sector lawyer for 24 years. I am an experienced litigator. I have an office full of experienced lawyers who I consulted with. I've done the research and I know all of the facts. I am confident in my legal opinion. I was exploring, and I was doing it in good faith, exploring this as an option. And it wasn't just in a day that I changed my mind. I did legal research, I did legal analysis, I consulted with the experts in my office, and I learned that, in fact, this is not a legal pathway forward. I wish that it was. It is not. And it doesn't matter whether you direct me or the mayor directs me. I can't do it consistent with my professional responsibilities. I don't know what else to say.
No, you've provided good clarity in terms of, once again, I asked for the formal process, which was not specified in this memo that was requested of the CAO, and being clear of what that chain of command was, because city attorneys also waged concerns during the settlement agreement when we were first asked to start that process. But the mayor and also opposed it, but this body and that branch of government eventually got on the same page and said, we want to enter into this agreement, in spite of the city attorney's office raging concerns. And because of that, because of the mayor's direction at that time, we enter into negotiations. So that's why, CAO Anderson, it's a little bit challenging to hear our city attorney say that they are holding the full responsibility for not exploring what provisions could be included and are not exploring any further a legal strategy that gets us a legally binding agreement when we've been here before in some ways, and there was a pathway that was advanced. But I recognize that there's other colleagues in queue. You've provided a lot more clarity to the public than I think has been in the past several months that we've had these discussions around how do we do a plan B and get a legally binding agreement. So with that, thank you for that. But I will pass it over to the rest of my colleagues.
Madam City Attorney.
Council members, the position that we're at right now is completely distinct than the position we were at when we were negotiating the settlement agreement to begin with. Again, we were negotiating legal claims, we were settling legal claims. We're done with that. We are now in a position where we have a fully settled dispute between us and MDHR. It would be an ethical violation for the mayor to direct me to do something that I have said is against my professional responsibilities, just like it is for you. So I don't expect that the mayor is going to direct me to do something in violation of my professional responsibilities. I hope that he takes the ethics code seriously and would not do that.
I put myself in queue because, well, now I do want to maybe take the temperature down a little bit. I've got our NIMS training printout in front of me, and one of the big principles of our national incident management system is managing by objectives. And I think that what Councilmember Wansley is trying to get to is an objective of a police department that is operating constitutionally. And I think we are just all very curious on how we can best achieve that outcome. And the memo that we waive privilege on, when I first read it, it was very confusing to me because it had a lot of government structure concerns and authority of the various branches also bundled up with our questions around how we achieve that objective of a constitutional police force that is reformed. And so I kind of want to just break some of the components of the memo down just so I have a better understanding of it. I think the clearest understanding is council as a body has certain authority, the mayor has certain authority, the city attorney's office as the sole legal representation of the institution doesn't just work for the council or just the mayor, but has to actually have that broader perspective. So when city council is directing the the city attorney. We are directing the city attorney to accomplish tasks that are within our authority. And when the mayor is directing the city attorney, it's only tasks that are within the authority of the mayor. I think where I think a lot of us are getting a little bit more confused is, it becomes clear that under that kind of framework of we only get to direct the city attorney to accomplish things that are within our authority, contract negotiations are not within our authority, so it would be improper for us to direct the city attorney to engage in contracts of any kind, settlement agreements inclusive. But it does seem that the mayor does have the authority to direct the city attorney to engage in contracts, and I'm wondering if you could unpack just like maybe two questions. One is, and this is, I also want to say, this conversation is happening in public so that we're building a deeper understanding for our community. And that is the nature of the council as a body. That is not the nature of the executive branch. They don't actually have to operate in public in the same way and have these debates and conflicts in public. Those debates and conflict can happen in meetings that are not broadcast on YouTube. So just to get an understanding, this is all uncharted territory. No one person in this institution is going to know the exact answer on the spot, including you. This has taken a lot of time to navigate. Out the gate, when we saw that the Trump administration was coming into office and anticipating that there could be this risk of it getting withdrawn, our very first meetings were about how unified we were, all 13 of us and the mayor, everyone, that we still want to deliver on this consent decree provisions. And this is ultimately our goal, is how do we best achieve that? Did the mayor specifically ask to incorporate the federal consent decree provisions into the settlement agreement? Was that ever a formal ask of the mayor that you also had to, and we did it in public. It's on our agenda right now as a direction. And we're learning about our ability to do that. Did you have to go through this exact same exercise with the mayor? Did he also ask you to incorporate the federal consent decree into the state provisions, and you had to also give him a similar type of legal explanation?
Council President, so we have all had conversations where you all 14 of you, have expressed interest in this idea. All of you.
I'm asking, did the mayor formally make a direction to that end that you had to kind of explain that was not within his authority to do, or did that not happen?
So the way that the mayor and I work is not by him issuing me formal directives. I mean, frankly, I'm not sure why this body is issuing me formal directives rather than having a sound attorney-client relationship with me. The mayor and I have discussed this. Again, he expressed interest, as all of you did. And I explained to him, when I concluded that there was no legal pathway forward, I explained to him that there wasn't a legal pathway forward and why. And he did not proceed to try to direct me to do something that is against my professional responsibility.
Well, I'll say that we do formal directives so that our community can follow along with what we're trying to accomplish. That's essentially the goal of that. So I think that was my main question. I can't remember what the second part of my question was. So if it comes back to mind, I'll get back in queue, but I see other folks in queue, and I'll call on Councilmember Chowdhury.
Thank you, Mr. Chair. Thank you, CAO Anderson. The one question that I have that I'm just trying to get a little bit further clarity on is just looking at Section 438. It pretty clearly states how modifications and amendment to the agreement are made. Parties may jointly stipulate changes subject to court approval, and there is not anything that articulates a necessity to have a dispute. So could you kind of explain that departure in how we're able to? It seems that we are just able to work with MDHR to make the modification as it has happened twice.
Council members, this is constitutional law. The court can only take jurisdiction when there is a case or controversy. In this situation, the idea of increasing an already settled settlement agreement by a third, adding all of these new terms, we would have to go back to the court and basically show the same things that we had to show to get court approval of the settlement agreement to begin with, right? We would have to show that, in fact, the new terms are necessary to resolve the dispute between MDHR and the city. I can't represent that. It's not true. They aren't necessary to resolve the dispute between MDHR and the city. We've already resolved the dispute between MDHR and the city. You also have to remember that the Federation tried to intervene in the proceedings when the settlement agreement was first approved. I can appreciate you all saying, well, why don't you just try it and see what the court does? The Federation absolutely will be right there to object. And again, I don't feel that I have a good faith basis to make those representations to the court. The court can't just expand its jurisdiction just because the parties want it to. The court has to always have a case or controversy that is before it. And the case or controversy between MDHR and the city, it's a very simple lawsuit between MDHR and the city having to do with claims of race discrimination. And all of those claims were already settled by the settlement agreement. What you're asking here is something extraordinary. Increasing by a third terms and adding them to a settlement agreement that has already been resolved between the two parties. Increasing the court's jurisdiction. This is about the jurisdiction of the court and what the court can exercise jurisdiction over. The dispute, again, between MDHR and the city has been fully and finally resolved. So to go to the court and say, court, I know that you have to have jurisdiction. I know that you have to we need to be able to show you that these terms are necessary to resolve the dispute before you, which is the lawsuit between MDHR and the city. I can't do that because it's not true.
Okay, that's my only question right now.
Councilmember Palmisano.
Mr. Chair, thank you. I think that the city attorney has said probably all that is needed to be said here, so I'll remove myself from queue now.
I added myself back in queue because I remembered the second part of my question, which was I think I've been trying to learn what's the technical term of art behind case or controversy, because I think it has more meaning than just what our kind of layperson's understanding of those words are. And I'm just curious, and I know that we have the example of using the modification provision for adjusting timelines, but what would be maybe an example of a case or controversy that would necessitate the need to make a modification on the substance, right, on some provision, on some specific paragraph? Like, what would be an example of that? And just recalling when I was wanting to amend the CCPO initially, there was I vaguely remember a conversation about it could require going through this kind of sophisticated modification process potentially, and that was very early in the process. I don't think it is required of us at this time, but what would be an example for us that would make sense for us to say, oh, okay, I see the difference between what we're trying to accomplish by including these federal provisions and what this version of a case or controversy is that would give you the legal basis for making that modification. Does that question make sense?
Not completely sure. So again, I mean, the issue here is expanding the settlement agreement by a third. That's what we don't have any case or controversy before the court to be able to do that. These additional terms that were not negotiated by the parties were not necessary to resolve this lawsuit between MDHR and the city. That's what we would have to show, that there is a necessity a correlation between those terms and the need to resolve the dispute between the city and MDHR, which we can't do because it's already resolved, right? So if what you're saying, could there be terms in the settlement agreement that that are not working the way that the parties thought that it was going to work? And would that justify going to the court for a modification of the language so that it actually aligns with what the parties actually intended? Potentially. I would have to see what the exact situation would be.
Maybe I could use a specific example. So we had a big section in the federal consent decree around First Amendment rights of journalists. And as we've discussed, that there isn't as direct a basis for including those in the state consent or the state settlement agreement because it's under state jurisdiction and not the First Amendment wouldn't apply in that case. However, some of those protections for journalists had specifics around use of force, which would be within the scope of a state settlement agreement. And perhaps our use of force section that we have agreed to in the settlement agreement isn't as expansive as some of those provisions that were outlined in the federal consent decree. And as an example, our use of force training is now being questioned in some scenario. Would that kind of us not meeting the expectation of the state be a basis of case or controversy that would necessitate a modification?
Council President, I'm having a hard time totally following the hypothetical, but I think the answer is no. I mean, we've already settled all of the claims about use of force with MDHR. We've already settled those claims with the terms that are in the settlement agreement. We wouldn't have a basis to ask the court to add on, because that's essentially what this is, adding on terms that have to do with journalists that were not part of the legal claim between us and MDHR, that legal claim, again, having already been completely settled.
Vice President Chugtai.
Thank you, Mr. Chair. City Attorney Anderson, I'm trying to wrap my head around legal justification to present to the court any terms that deviate from what is written exactly as it exists today, or what was approved by the court. So I do remember, there are several terms within the settlement agreement that allude to a potential federal consent decree. I remember, in public communication with our community that several times the city has and the Minnesota Department of Human Rights both have explicitly talked about the intent of making sure there are no conflicts between the settlement agreement and a potential consent decree, right? Both parties were always planning for there to be a third party involved as well. In fact, I believe that your office and you consulted with that third party a couple of times when certain language was being finalized. I remember hearing about this. So is the intent that there were eventually going to be modifications made to align with a third agreement or a second agreement not enough of a legal basis? I'm just wondering if you can speak to that a little bit. I'm sure you considered this as a part of your legal review.
Yes, council members, I did consider that. Again, we did account for a conflict, and the parties negotiated that. We negotiated if there was a conflict between the terms of the federal consent decree and the settlement agreement that we would go back and renegotiate that. And that term is explicit, and it was approved by the court. And if that was the situation, we would have a legal basis to go back to the court with, hey, these terms are conflicting. Here's the new term that actually aligns with the federal consent decree. But other than that, we did not account for what's now happened at all. Right? I mean, I wish, hindsight being 2020, we could have accounted for it. We didn't. And instead, we fully settled all of the legal claims of MDHR. So there is not a legal basis for MDHR to come back and say, well, this thing that we thought might happen won't happen. So psych, never mind. We don't have a resolved dispute. We have fully and finally resolved that dispute.
I am not seeing anyone else in queue, so I will direct the clerk to receive and file that memo on item 3.1. We still have to dispose of item 3.2, which is the staff direction from Councilmember Wansley. That was the subject of the memo that we released privilege on, and I will recognize Councilmember Wansley to speak on this item.
Thank you, President Payne. Again, appreciative of having the discussion beforehand, and as you highlighted, having a public discussion because, of course, we have heard from residents the shared desire to make sure that the provisions that were in the consent decree also be legally reinforced. And I think it's important to regroup or reground this conversation, the fact that we approached our city attorney's office for 6 months with that same intent of finding a plan B, and were informed that it was viable. And when something that was shared around, like it wasn't just a, day, 24-hour decision to have a change in legal opinion. I will note we had a closed session literally around mid-May, where we were still under the same assumption that there was still a pursuit in collaboration with MDHR. And then literally a week later, we had a smaller group meeting with some other of my colleagues in the city attorney's office where we first learned of this very different opinion. And it was a 180. So it did present itself as sudden, abrupt, conflicting information. And that is not something that we want to present to the public ourselves. We want to make sure there is a coherent basis as to why the public will not see the city pursuing a pathway to make sure that there's legal codification of these 300 plus terms that could ensure that our police department got into compliance with constitutional law. And I get the reiteration of an executive order and saying that we're doing it anyways, but quite frankly, and what is highlighted even in the investigative reports for the MDHR and the Department of Justice, is the fact that the city could have been doing it anyways for several years, and it did not. And that has caused a world of harm for so many of our residents, and it's put the city in fiscally precarious positions too, because we didn't do everything that we could to make sure our police department was in compliance with human rights and constitutional law. So I wanted to reground. This conversation didn't just happen overnight. It happened because we did take the advice of our city attorneys. We were hopeful and were affirmed that this was a viable pathway. And as of early June, we were told something completely different. And it's also concerning to be in a position to see our article be released today that has your former city attorney saying that this is also possible, or seeing the ACLU Minnesota attorney say it's not really a complicated legal thing, or seeing, additional legal experts highlight that there is a way forward. And it just feels like we want to make sure walking away from this process, we're not leaving anything on the table. But I will highlight, one thing that the CAO reference is us taking action on this matter will then incite potential ethics violations on behalf of council or the mayor should either party decide to direct the city attorney to not leave anything on the table and to find a legal pathway, to bring in experts, to do whatever possible to see, are we missing anything? And while I think an ethics violation is completely warranted if we're talking about making sure our police department is upholding constitutional rights, I understand that's not a risk that colleagues want to take. And possibly maybe not the mayor, who has the authority of the police, but I think it's worthy. And I think it's important that we are exploring all options and not just leaving an executive order to be the only mechanism for supporting accountability when it comes to constitutional policing. But in light of that, I'm more than happy to refer this motion back to me as the author. So I will make that motion and ask for a second.
Second.
But I at least wanted to reground the conversation because, again, there's been the inclusion of this is a personal attack or this is violating integrity. And it's literally been a shared basis for over 6 months that I thought everyone was on the same page. And we've said we've all been on the same page around getting legally binding enforcement behind the federal consent decree terms. And it seemed as if we all were marching together towards that goal, and then someone got off the parade in June. And so while I don't want to have this referral or motion signal to the public that council is backing away from its commitment to doing everything possible to get a legally binding agreement, and I do think there is still a pathway, either through the mayor's office figuring out a way to do so. And I want to say thank you, President Payne, for issuing that letter that still puts the offer on the table for the mayor's office to work with council to figure out how do we do this work still. But I at least want to note that it does not feel like all hope is lost. I don't necessarily agree with that aspect with our city attorneys, but I do understand it's somewhat the basis for this motion. It's not in our authority to direct you. And on that basis, I'll make that motion, but I don't necessarily buy that it's impossible for us to figure out a legal strategy to pursue that legal binding pathway. So with that, I'll ask my colleagues to support the motion.
Council Member Wansley has made a motion to return to author, I think, correct? Right. And that's been properly seconded. Is there any discussion on that?
I can't get in the system.
I can't either. I was going. Councilmember Rainville.
Thank you. I can't get in the speaker management system, but I just want to thank you, City Attorney Anderson, for your patience with all of us through this. It's been quite an ordeal. None of us are attorneys. You're the attorney. None of us have the expertise you did, and I appreciate you taking all the time and effort to thoroughly resolve this issue. So thank you very much.
And is there anybody else that wanted to get in queue and have problems with speaker management? Yeah. I was just going to say thank you, Councilmember Wansley, for bringing up the letter. It was something that I had collaborated with the city attorney on as we were really trying to figure out what is our path. We don't know what it is. It's not entirely clear. And in the spirit of actually still moving us towards that shared goal, I would definitely like, now that we're disposing of these items, for us to really get on the calendar, maybe a small group of us, plus the mayor, plus the clerk, could at least brainstorm about what options are available to us to get to that shared goal that we have all expressed, that there isn't actually a lot of conflict around, I don't believe. I don't know that there's going to be any queue, so I'll just
refreshing.
Ask all those in favor of returning this back to author, say aye.
Aye.
Opposed, say nay. Any abstentions? The ayes have it. That motion carries. And now I will return the chair back to Councilmember Chavez for our standing committee reports.